Good morning, students. Today we are going to review the questions given on performance and breach of contract. Please understand, both the topics are very important on exam point of view, not only in CPT level but also in IPCC level. So it is very obvious to understand the meaning before going into the topic. What do you mean by performance? We all know that agreement, when enforceable by law, becomes a contract. So once the contract is formed, now the question is to discharge the contract. How to discharge the contract? Obviously, the parties to the contract should perform their obligations to discharge their contract. Example, both of us enter into a contract. You enter into a contract of you propose to sell some electronic goods and I propose to pay some cash. When you sell the goods to me, it is obvious that your performance is discharged and my performance is pending. Now I have to pay cash. Once I pay cash, both of us have discharged the liability. Hence, the contract is completed. So the intention is to complete the contract. Now this leaves a question: is the only way to discharge the contract is by performing it? The answer is no. A contract can be discharged even by non-performance. A contract is based on the agreement. Similarly, a contract for not performing also can be made. So, who should perform the contract? The parties of the contract should perform the contract. Now, once again, the is there any other way in Indian Contract Act wherein the parties can the parties can appoint any representative or agents to perform the contract? The answer is yes. The contract can also be performed by agent or representatives. As we all know, consideration need not move from the promisee itself. Some other person can also make payment on behalf of the promisee. Further, let us discuss what is meant by joint promise. Joint promise is something where four or five persons, or even more than, not more than 2% or 2% can enter into a contract, can undertake to discharge the contract jointly. Now this leaves various questions. What if one of the promisor is not able to discharge his obligation? Then what is the fate of the promise? Then the liability or duty of the other rest of the promisors. So what is the fate of that? All these needs to be discussed over here. So in case of joint promise, please do understand the liability of each promisor is joint and several. Joint means each and every promisor is liable for the whole amount. Several means they are also liable for the proportionate amount. That is, if there are three parties, assume that one of the party is not able to discharge the performance, the other two parties to the contract have to discharge the contract on proportionate basis. Assume if two of the parties are not able to discharge the contract, the remaining one have to completely take the liability in discharging the contract. Now we have one area called specific performance, which needs some explanation. As I told, the performance of the contract can be made by the representatives and agents. It is not so in all the case. Assume that a person is entering into the contract of singing in a concert. So he can't appoint some other person to sing on his behalf. He has to specifically perform on his own. So these are the instances where specific performance of the contract is important. Next, we will go to time of performance of contract. Time of performance of contract basically indicates when the contract needs to be performed. When is the question of time. The time of performance of contract is basically indicated in the agreement itself, that is contract itself. If it is not indicated, the contract needs to be performed within reasonable time. Once again, reasonable time is a matter of question, it's a matter of fact. It differs on each case. Now let me tell you an example. A borrows from B rupees 10,000 without mentioning the time of repayment. So after a month, they undertake to go for a forest trekking. So on the way of trekking, they are threatened by a thief to surrender the belongings. Now what A does is he cleverly, understanding the situation, repays the dues in front of the thief to B. So can he do so? This is based on time of performance of the contract. Now we all know he has discharged his liability, but is it the right time to discharge the liability? No, because his intention was not to repay and he knows that the money will not reach the lender, that is B. His performance was not intended to discharge the contract. So next to time, the important thing is date of performance. So assume that the date of performance is indicated in the contract, but the time of performance is not indicated. So it is obvious that the performance may be during the usual business hours of the indicated date. Now, now that we have clarity in time of performance, let us understand the place of performance. Place of performance is where. Where should the contract be performed? Place of performance should be indicated in the contract. If place of performance is not indicated in the contract, it is the duty of the promisor to ask the promisee to fix the place of performance. Moving to next topic, we have a topic called impossibility of performance. What is mean by impossibility of performance? There are certain cases where a contract cannot be performed. For example, India contracts with some other country to import the goods. A person in India, sorry, to import the goods. Now subsequently, the government bans import from that particular place. It becomes an impossibility of performance to execute the contract. So such impossibility, if it is known to the parties at the time of entering into agreement itself, the agreement becomes void. When I say the agreement is void, it is void ab initio. It is void at initial stages. No contract comes into force. If it is unknown, then the contract becomes void. If it is known to the promisor alone, then promisee can claim damages for not intimating him about the impossibility of performance. Now let us understand what is meant by supervening impossibility. Supervening impossibility means it is a situation where performance becomes impossible because of legal or circumstances which is beyond the contemplation of the parties. So the example which I quoted is similar to supervening impossibility. The next topic is appropriation of payment. Now, if a person is making the payment and if he is intimating his intention of appropriation, then payment shall be appropriated in such manner. If there is no such intimation by a person who is making payment, then payment shall be appropriated in the order of time which they are due. So there are also certain circumstances where contract need not be performed. Example, novation, rescission, alteration and waiver by the promisee. So to conclude, discharge of the contract can be done in any way, that is by performance, by mutual agreement, by impossibility of performance, by lapse of time, operation of law and breach of contract. Now let us understand what is meant by breach of contract. Breach of contract is failure to perform the obligations of the contract. Such breach may be actual breach or anticipatory breach. So actual breach is the time of performance has come, and if a party is not performing, it is obvious that there is a breach of contract on behalf of the person, who has not performed, and hence aggrieved party has the right to claim for damages. Anticipatory breach is something which a person anticipates that the other person would breach the contract. In the example which I gave in supervening impossibility, that is banned by government to import, it is obvious that there is a element of doubt that the contract shall not be performed. So it is called as anticipatory breach of contract. So liability for breach of contract may be special damages, vindictive or exemplary damages, and vindictive or exemplary damages can be given only in two cases, that is breach of promise to marry and wrongful dishonor of check by bank. And next you have nominal damages, which is given in case if there is no loss sustained to the aggrieved party. The damage can be even 10 paise or 1 rupee. And the last one is damage for deterioration. So now that we have discussed what are the liabilities for breach of contract, the ways of damages to be calculated needs to be discussed. We have certain ways to calculate the damage. For example, rescission. When we can rescind the contract if the agreed party feels that there is no point in continuing the contract after the damage has been done, he can rescind the contract. As I told, specific performance is one way to compel the promisor to perform the contract. Next we have is quantum meru. Quantum meru is nothing but as much as earned. If there is a breach of contract, the party who has breached the contract certainly would have some benefit of the breach. So in that case he has to restore all the benefits as much as he earned to the agreed party. This is called as quantum meru. The last one we have is injunction. Injunction is the order to restrain from doing certain act. So with this introduction, let us move on to the questions. First question: X, Y and Z jointly promise to give rupees 10,000 to Mr. A. Mr. A can enforce the contract jointly, severally, specifically, both jointly and severally. The answer is both jointly and severally. As I told, in case of joint promise, the obligation of the party is the entire liability, that is jointly, and also proportionate liability, that is severally. So hence in this case the answer is jointly and severally. A receives some money from T to pay to P. A admits of this receipt to P. The options are: P can recover the amount from A, P can recover the amount from T, A will pay the money back to P, A can keep the money from himself. The answer would be P can recover the amount from A. This is because by A receiving the money from T, T has discharged his liability and now it is A's liability to discharge his liability by paying to P. Hence P can recover the money from A. The following contractual rights cannot be assigned. Option A is under a contract not involving personal skill. Second one is actionable claim. Third one is upon death of the party, upon his heirs and legal representatives, and the last one is contracts involving personal skill. The answer would be contracts involving personal skill. This is governed by section 37 of Indian Contract Act. Accordingly, assignment of rights means transferring the interest or benefit to the contract to other person. So obviously in case of personal skill, there is no chance there is no way you can assign that skill to other person and ask the other person to perform the contract. Now question number 4: if no place is fixed for the performance of the promise, Option A, it is the duty of the promisor to ask the promisee to fix a reasonable place. It is the duty of the promisee to ask the promisor to fix a reasonable place. Performance can be made at any place, both A and B. The answer is it is the duty of the promisor to ask the promisee to fix a reasonable place. This is already discussed. It is discussed under section 49 of Indian Contract Act, which says it is the duty of promisor to ask the promisee to fix a reasonable place if no place of performance is fixed. So A undertakes certain goods to deliver on fixed day. A must apply B. A must apply to B, to whom he has entered into the contract, to appoint a reasonable place for the purpose of receiving it, and must deliver it to him at such place. The fifth question is, X promises to deliver 10 TV sets of Y in case of X's death before performance. X representatives, option A, shall be bound to deliver the TV to Y, shall be bound to deliver the TV to Y, but their liability is limited to the value of property inherited from the deceased. C, A are not bound by the promise. Option D, shall terminate the contract. The answer should be shall be bound to deliver the TV to Y, but their liability is limited to the value of property inherited from the deceased. The reason is representatives are the one who takes in charge of assets of the deceased person in order to discharge the liability of deceased person. Hence, the liability of representative will be restricted to the assets of the deceased person. Sixth question, a contract is discharged by supervening impossibility. The options are when change of law takes place subsequent to the contract, on the death of the party who has to perform the contract personally, non-existence of particular state of things, and D is all of the above. The answer should be all of the above. According to Indian Contract Act, supervening impossibility may take place owing to the following, that is unforeseen change in law, destruction of subject matter of the contract, and non-existence of particular state of thing which was naturally contemplated for performing the contract. Hence, all the three will apply. Seventh question, X owes Y totally rupees 50,000. He sends a check for rupees 20,000 stating that it shall be appropriated towards his first sum of 20,000 that he took from Y. Y shall appropriate it towards the debt as indicated by X. Option B, the debt due from X. C is any disputed debt due from X. The last one is any time barred debt due from X. The answer is the debt indicated by X. Now this is based on appropriation of payments. There is a Latin maxim which says quicquid suavitur secundum modum solventis, which means whatever is paid according to the intention or manner of the party paying. This is also governed under section 59 of Indian Contract Act. Now eighth question, which of the following statements are true? Option A, at the time of payment the debtor has the right of appropriating the payment. Option B, in the following in the default of debtor the creditor has the option of election. Option C, in default of either the law will allow appropriation of debts in order of time. Option D, all of the above. The answer obviously is all of the above, because section 59 to section 61 of Indian Contract Act says, see, the point number 1, debtors right to pay the debts is already discussed in the question, which in the above question, which is covered under section 59. Now according to section 60, if the debtor has omitted to intimate on how the payment is to be applied, the creditor may apply at his discretion to any lawful debt actually due and payable to him. Also, section 61 says, when neither of the parties make any appropriation, then the payment shall be applied in discharge of his debts in the order of time. Hence, all the three are correct. Now, question number 9. A contract stands discharged by performance of the contract, by breach of the contract, by agreement and novation. Option D is by all of this. The answer is by all of this. Now, this is covered under discharge of contract. Once the obligation under the contract is performed, the contract is said to have discharged. This means the contract is complete. If there is a breach of contract, the other party has the rights to treat the contract repudiated, and hence contract becomes void and discharged. The term discharge should be construed to give effect that the contract has dead, no matter it is dead before because of performance or non-performance. A contract is formed by an agreement, and hence it can also be dissolved by an agreement to this effect. Now finally, novation means substituting new contract for old. It means old contract has got discharged. So by all the three means, the contract stands discharged. Question number 10. In which of the following cases a contract is not discharged on ground of subsequent impossibility? First one is destruction of subject matter. Second one is option B is death of promisor. Option C is commercial hardships. And option D is change of law. The answer is commercial hardships. It is already discussed that in case of subject matter is destroyed or in case of death of promisor, the contract stands discharged. Change of law, it is covered under supervening impossibility, with the effect is also the discharge of contract. The left alone option is commercial hardships. So commercial hardship means the contract is not commercially viable. Hence, this does not account for a contract to be discharged under supervening impossibility. So the answer would be commercial hardships. 11th question. An agent may retain out of sums received on account of principal in the business of agency. The options are A. Remuneration as may be payable. B. Expenses properly incurred. C. All sums due to himself. D. All of the above. The answer is all of the above. The question is basically covered under performance of contract through agent. Under Indian Contract Act, where personal consideration is not a foundation of contract, then the promise can be performed by agent also. Hence, agent will collect the amount from the third party to repay to the principal. On making such payments, the agent is entitled to recover his remuneration and all other sums or reimbursements due to him. Hence, the answer is all of the above. Now moving to question number 12. X promises to drop the prosecution which he has instituted against R for robbery, and R promises to restore the value of things taken. Option A. X can enforce this promise because they have mutually agreed. Option B. No, X can't enforce because it would defeat the very provisions of law. Option C. No, it cannot be enforced because both the parties cause to the original position. Option D. Yes, X can enforce the promise to overtake to the original position. The answer is no, X can't enforce because it would defeat the very purpose of the contract. This is based on the concept called stifling of prosecution. Now, by dropping the suit by X against R, Mr. X is accepting a contract for which the object is unlawful. Hence, X cannot enforce to drop the prosecution. Now let us move on to 13th question. A contract need not be performed. Option A, when its performance becomes impossible. Option B, when it is altered, rescinded, substituted for a new one. Option C, when the promisee disperse with it. Option D, all of the above. The answer is all of the above. Now once again, this is based on performance of contract. In case of supervening impossibility, a contract becomes impossible to perform. Also, when the terms of contract are altered or rescinded, or when promisee himself waives the contract, the original contract gets discharged. Hence, in all the cases, the contract need not be performed. Question number 14. X, Y and Z jointly promise to pay rupees 3000 to A. In the absence of express agreement to the contrary, A can bring action against option A, any two of them only. Option B, all of them together. Option C, any one of them at his choice. And option D is the oldest among them. The answer is any one of them at his choice. Now this is based on performance of the contract. As already discussed, in case of joint promise, each promisor is jointly and severally responsible to execute the promise. Hence, A at his option can bring in action against any one of them. Bringing action against any one of them does not dispense the others from the action. They are also liable to discharge the promise. Now let us move on to question number 15. A contract is not discharged on the ground of supervening impossibility. Option A, on difficulty of performance. Option B, strikes, lockouts and civil disturbances. Option C, outbreak of war. And option D, all of the above. The answer is all of the above. As already discussed, these are all the cases where law of supervening impossibility is applied. So once the law of supervening impossibility applies, and once the contract cannot be discharged, that is the obligations of the contract cannot be discharged, then the coverage, that is on difficulty of performance, strike, lockouts and outbreak of war, all the three applies in this case. Now let us move on to question number 16. X, Y and Z jointly promise to pay 10,000. A may compel X, Y and Z jointly and separately to pay rupees 10,000. Option B, X to pay him rupees 10,000. Option C, X, Y and Z jointly to pay him rupees 10,000. Option D, X, Y or Z to pay him rupees 10,000. As discussed, the answer obviously would be X, Y and Z jointly and separately to pay rupees 10,000. This is once again based on joint promise, which says each promisor is jointly and separately liable to pay the discharge the obligation of the promise, and hence A may compel jointly and separately to pay rupees 10,000. Question number 17. Ram, Rohit and Kiran jointly borrowed rupees 2 lakhs from Rahim by executing a promissory note. Rohit and Kiran are not traceable. Rahim wants to recover the entire amount from Ram. Ram objected this move by saying he is liable to pay 1/3 of the debt only. Which of the following statement is correct? A. Rahim can recover the entire amount from Ram. B. Rahim can only recover 1/3 of 2 lakhs from Ram. Rahim cannot recover any amount from Ram. And last one is the promissory note is not executable against Ram as Rohit and Kiran are not traceable. The answer is Rahim can recover the entire amount from Ram. Once again, it is a joint liability and Ram has to pay the entire amount even if the other parties are not able to pay, because it is a joint liability. In case of joint liability, the obligation of the single party, that is the left out party, that is Ram, is on the entirety, that is the entire amount shall be paid by Ram. Question number 18. A direct B's whose solicitor to sell his estate by auction and to employ an auctioneer for this purpose. B names C as an auctioneer to conduct the sale. The status of C for the sale is C is the agent of A, C is a sub-agent of A, C is agent of B, C is neither an agent of A nor B. The answer is C is an agent of A. This is because C is selling the estate on behalf of A only. Now, question number 19. Dash can perform the contract. Option 1, that is A, promisor alone. Option B, legal representative of promisor. Option C, agent of promisor. And option D, all of these. The answer is all of this. This is already discussed because performance of the contract need not be made only by the promisor. The promisor has the right to appoint the agent or legal representative. Question number 20. Where a certain amount is deposited as securing for performance of contract, it is called earnest money, cash money, hard money, all of this. The answer is earnest money. Earnest money deposit is something which is made to show the good faith in the transaction, that is buyer's good faith in the transaction. The other three, that is cash money, hard money and all of this, is neither by way of deposit, hence the answer is earnest money. In this question, if you see, it is for securing the performance of the contract. Obviously, securing the performance of the contract indicates that there is an intention to show the buyer's good faith in the transaction. Hence, earns money deposit would be the correct answer. Question number 21. Reasonable time of performance of the contract is question of fact, question of prudence, question of law, mixed question of fact and law. Question of prudence and question of law does not apply because this is a time of performance, and law, once there is no specific agreement as to perform the contract in reasonable time, there is no question of law because there is no indication in the agreement itself. Question of prudence is subjective. This is question of fact. Question of fact differs on each case to case. Hence, the answer would be question of fact. When a contract expressly provides for the order of performance of reciprocal promises, the promises shall be performed in A. Any reasonable order, any appropriate order, C. Any order, D. The order mentioned and not otherwise. The answer is the order mentioned and not otherwise. Since the order of performance is already agreed, the same shall be performed based on the agreement. Question number 23. Where the price of goods is to be fixed by the third party and such third party refuses to fix the price, the contract becomes void, voidable, illegal, void and illegal. The answer is void. This is once again based on performance of the contract. According to that, the price can be fixed by the third party. If the contract is dependent on third party to fix the price and if he fails to fix, then the contract becomes void. In case of joint promise, promisee can compel A. all the joint promisers to perform, B. any one of them to perform, C. some of them to perform, and D. any of the above. The answer is any of the above. The reason being, the liability of joint promisor is joint and several. So question number 25. On substitution of new contract, the old contract is discharged is known as rescission, novation, alteration of the contract, waiver. The answer is novation. Rescission means rescinding the old contract and no new contract comes into existence. So in case of rescission, please understand, if you rescind the contract, there is no new contract. The old contract is discharged, and in substitution there is no new contract. But in case of alteration, it is the terms of contract that is getting altered by mutual agreement. But novation means substituting the old contract with new one. So the answer would be novation, obviously. So question number 26. In which of the following situations specific performance can be granted? Option A, when there is no exact substitute for or alternative to the subject matter of the contract. Option B, when there is probable that compensation in money cannot be got for non-performance. Option C, A or B, and option D, A and B. The answer would be A and B. This is based on performance of the contract. Specific performance is required when there cannot be a substitute for performance by a promisor himself, or there is no monetary compensation for non-performance of the contract. Hence, under both A and B, the promisor has to perform the contract. Question number 27. A polished B's shoe without being accepted by B to do so. B does not make any attempt to stop A from polishing the shoe. Decide. B is bound to pay. Option B, B is not bound to pay. Option C, B is bound to pay the damages any incurred by A. Option D is none of these. The answer is B is bound to pay. Now this is covered under implied acceptance and performance of the contract. By B not stopping Mr. A from polishing his shoes, he has accepted the offer to polish the shoes. Hence, his liability is to discharge the consideration for whatever service he has been obtained. Question number 28. When both the benefits and burden devolve on legal hire, it would be called as A. will, B. assignment, C. delegation, and D. succession. So under will, the benefit such as asset is transferred. Under assignment, the liability of performance of a specific contract is made. Delegation means appointing an authorized representative to carry out an obligation or act. So hence succession is the term which is used for transferring both benefits in form of assets and burden in form of liabilities on the legal heir. So the answer would be succession. Now the answer question to 29, question number 29. A owes B rupees 1000 but the debt is barred by limitation. A agrees to pay him rupees 500 on account of debt. Option A, B can recover 500. Option B, B can recover only 1000. Option C, B can't recover any money. And option D, A shall pay rupees 1000 along with interest. The answer is B can recover rupees 500. This is covered by time of performance of contract. Since the debt is barred by time, the original liability of rupees 1000 cannot be demanded as a matter of right. Hence B has to accept whatever is given by A. So the answer would be 500. So question number 30. A contract is discharged by rescission, which means the A, change in one or more terms of the contract, acceptance of lesser performance, abandonment of rights by a party, cancellation of the existing contract. The answer is cancellation of the existing contracts. Change in terms of contract, acceptance of lesser performance, abandonment of right, it means alteration. All the three cases means alteration. But here we are talking about cancellation. So rescission means putting an end to the contract. So no new contract comes into existence. So the answer is D. Question number 31. Ordinarily, the following damages are not recoverable. Option A, ordinary damages, special damages, nominal damages. D is exemplary damages. The answer is exemplary damages. Exemplary damages are also called as punitive damages or vindictive damages. They are not recoverable in case of suit. This is awarded as a punishment for reckless or willful act. This is often awarded as a punishment or to set as a public example. Question number 32. Effects of illegality. A, collateral transaction is illegal. B, no action can be taken for breach of illegal agreements. A and B above and none of this. The answer is A and B above. This has reference to illegal contract. If the main contract is illegal, the collateral contract also becomes illegal. Hence it is true. Agreement becomes contract only if it is enforceable by law. Hence action cannot be taken against breach of illegal agreements. Hence this is also true and the answer is A and B above. Question number 33. A bought a motor car from B. He used it for 3 months and thereafter the car was detected to be stolen and A was compelled to return the car to the true owner. The options are A could recover the price from B. B, A can claim the damages from B. C, A cannot recover anything from B. D, B will replace the car. The answer is A could recover the price from B. This is based on breach of contract. The basic maxim is nobody can sell a thing which he does not possess. If he sells, he has to compensate for loss and hence A can recover the price from B. Question number 34. Non-fulfillment of an obligation which one is bound to do under the contract is called avoidance of contract or breach of contract, voidability of contract or rescission of contract. The answer is breach of contract. Voidability of contract comes before the existence of contract. Rescission is one way to discharge the contract, but when contract is legally entered into but the obligations under it are not fulfilled, then it amounts to breach of contract and hence the answer is breach of contract. Question number 35. X, a shopkeeper, leaves his goods at Y's place by mistake. Y treats it the same as his own and uses it. Y is bound to compensate for it under the principle of the options are A, quantum meru, B, damages, C, specific performance, D, rescission. The answer is quantum meru. Quantum meru means, as discussed, as I told, it is as much as earned. Hence Y has to compensate the loss to the extent of his own earnings. Question number 36. cold drink was supplied by A to B in bottles. B was injured by busting one of the bottles. Can B claim the damages from A? The options are: B can claim the damages from A for injury, B cannot claim the damages from A for injury, B can get the new bottle from A, and none of the above. The answer is B can claim the ordinary and special damages towards it. That is, B can claim damages from A for injury. Not only the normal damages, he can also claim special damages if any attributable to the injury. Question number 37. If default is by joint promisors, the promisee can sue any one of them for the entire promise. The answer is, so the options are true, false, partly true, and none of the above. The answer is true. Once again, this is based on the principle of joint promisee, where in case of joint promise, the promisors are jointly and severally responsible to discharge the debts. Hence, if there is any default by joint promisor, the promisee can sue at his option can sue any of the promisor for the entire amount. Question number 38. To file a suit under quantum meru, the original contract must have been discharged by breach of party by non-performance. It is options: A true, B partly true, C false, and D none of the above. The answer is true. This is based on breach of contract. Quantum meru means as much as earned. Where a party has not discharged the liability under the contract but has got benefited from the contract, it is the duty of the party to reimburse as much as earned to the affected party, that is aggrieved party. Question number 39. A contract to sell his TV to Y for rupees 5,000 and Y agrees to pay on delivery. Once the TV is delivered to Y and Y pays rupees 5,000, the contract comes to end. This is known as rescission of the contract, waiver of the contract, discharge of the contract, breach of the contract. The answer is discharge of the contract. Since both the parties of the contract have discharged their own obligations, the contract is called as discharge of contract. Rescission of the contract means rescinding the contract, that is dropping the contract. Waiver of the contract means agreeing that certain terms of the contract need not be performed. Breach of contract means not performing the contract. Hence, the other three options will not apply in this case. The answer is discharge of contract. Question number 40. X promises Y to perform a music concert for 4 days continuously. A willfully absents on 4th day. Y rescinds the contract. In such case, for loss sustained due to non-performance in 4th day, A. Y can claim the compensation, B. X can claim the compensation, C. X cannot claim the compensation, D. X cannot claim the compensation. The answer is Y can claim the compensation. In case of it is a breach of contract. So under the breach of contract, the aggrieved party has the right to get compensated for ordinary damages and special damages. Hence, Y can claim the compensation from X. Question number 41. In case of breach of contract of sale, A. Buyer can always sue for interest on the amount of price paid in advance. Nobody can sue for the interest. C. Seller can always sue for the interest on the amount of price. D. Seller can sue for the interest on the amount of price, or buyer for the interest on amount of price paid in advance, as the case may be. So the answer is seller can sue for the interest on the amount of price, or buyer for the interest on the amount of price paid in advance, as the case may be. In case of contract of sale, one party always agrees to pay the price for getting some benefit. So in case of breach of contract, the price of the contract can be claimed. Now assume that the party is also paying some advance and the other party repudiates the contract by not performing. He has breached the contract. In such case, the interest, that is the time value of money of advance, has to be taken into account. So interest has to be paid for the advance or whatever money he has paid to the party who has breached the contract. Hence the answer is D. Question number 42. X agrees to deliver 100 bags of wheat to Y at certain price on 2nd October. If X has performed part of the contract, say 80 bags, and then refuses or fails to deliver the remaining goods, it amounts to A. Anticipatory breach during the course of performance. B. Actual breach during the course of performance. C. Anticipatory breach on the due date of performance. D. Actual breach on the due date of performance. The answer is B. Actual breach during the course of performance. As already discussed, actual breach takes place when the time of performance has come and the party to the contract is not performing to the during the time. Anticipatory breach is something the party anticipates that the breach may happen. So in this question it is an actual breach because the time of performance has come. He has delivered only 80 bags. So hence answer option B is correct. Answer to question number 43. Remedies available for breach of contract by firm or dissolution of firm. B. Charging extra fees from the party committing the breach. Suit for specific performance. None of the above. The answer would be suit for specific performance. Dissolution of firm is something the firm gets dissolved. A person who aggrieved person because of the breach of contract cannot go and ask the firm to get dissolved. Similarly, charging extra fees from the party committing breach, that is not an once the price of the contract is fixed, there is no point in increasing the price. Only the aggrieved party has the option to claim the damages and not charge extra fees. So in this given on the given four options, option C, that is suit for specific performance, is more correct for this question. Question number 44. Suit for specific performance and suit for injunction. Option A are remedies which provide the same result. Option B are different remedies and they provide different results. Or option C are not the correct way to act against the party committing the breach. Option D are the only correct way to act against the party committing the breach. The answer is they are different remedies and they provide different results. Option B. Now we have to understand the two terms, specific performance and suit for injunction. Specific performance, already discussed, is compelling the promisor to perform the obligation as there is no other alternative. But suit for injunction is something like detaining or reserving the right not to use the property or reserving the right not to enforce the contract. So it is a different it's a different concept altogether. So suit for injunction need not be confused with specific performance. Under specific performance we are compelling the party to perform, but under suit for injunction we are restraining from doing certain act. Now moving to question number 45. A invited B to birthday party. B promised to attend and gave A rupees 500 as promised to attend and give A rupees 500 as present on his birthday. But B failed to attend. What are the remedies for A? A cannot recover any damages from B. B. A can file suit for recovery of rupees 500. C. A can file a suit for breaking the promise. D. A cannot file a suit for breaking the promise. The answer is A cannot recover any damages from B. This is because it is a social contract. This is based on a decided case law called Balfour vs. Balfour, under which it is decided that social contracts cannot be enforced under the court of law. So hence breach of this will not entitle any damages to be recovered. The answer is A. Moving to question number 46. If a creditor does not file a suit against the buyer for recovery of price within 3 years of debt, the debt becomes time barred and hence irrecoverable, time barred but recoverable, not time barred, and none of this. This is in line with the Limitation Act 1963, which says if a debt is not recovered within 3 years, then it becomes time barred, and hence the answer is it is time barred and hence irrecoverable. Question number 47. The damage awarded by way of punishment is called A. Vindictive damages, B. Special damages, C. Nominal damages. D. Ordinary damages. The answer is vindictive damages. Other three damages are not by way of punishment. Vindictive damages, which is also called as exemplary damages, is by way of punishment or setting an example. Question number 48. Breach of contract may be actual breach, anticipatory breach, A or B, and A not B. The answer is A or B. This is already discussed. Breaches of two types, actual and anticipatory. Question number 49. Vindictive or exemplary damages may not be awarded. A for breach of promise to divorce, B for promise to marry, C for wrongful dishonor by banker of his customer's check, D and none of this. This is from liability for damages. According to that, vindictive damages can be awarded only for breach of promise to marry and wrongful dishonor by banker of his customer's check. Hence, the answer would be for breach of promise to divorce. Question number 50. A invites B to stay with him during winter vacation. B accepts the invitation and informs A accordingly, when B reaches A's house, he finds it locked and he has to stay in a hotel. Can B claim damages from A? The answer is B cannot claim any damages from A because this is a social contract and cannot be enforced in the court of law. Thank you very much.